Welcome to The Explainer. Hey everyone, if you're gearing up for your CA Foundation exams, you know that contracts are a huge deal. So today, we're going to zoom in on a really critical piece of the puzzle. What happens when a promise gets broken? Let's break down breach of contract and all the remedies that come with it.
So here's a quick look at our game plan. We're going to kick things off by defining what a breach of contract actually is. Then we'll get into the two main types, which is all about timing. From there, we'll open up the legal toolkit and explore the 5 key remedies, taking a deep dive into financial damages first, and then looking at those times when, money just isn't the answer.
All right, let's jump right in. Before we can even think about fixing the problem, we have to know exactly what the problem is. So what does it really mean, in legal terms, when we say a contract has been breached?
Honestly, it's pretty much as simple as it sounds. A contract is basically an agreement with rules. A breach is when one of the parties just fails to follow through. They don't do what they promised to do. It's a failure to perform their side of the bargain, and that's the bottom line.
Okay, now things get a little more specific. A breach isn't just one single thing. It can happen in a couple of different ways. And the key difference, well, it's all about timing.
So here's the crucial distinction. It's when the failure happens. If someone straight up tells you they're not going to do what they promised before the date they were supposed to do it, that's an anticipatory breach. But if the date comes and goes and they just don't perform, well, that's an actual breach.
And this is a perfect example of an anticipatory breach by conduct. You see, A didn't even have to call B and say, "I'm not selling you the horse." By selling it to someone else on August 1st, his actions have made it totally impossible to fulfill his promise to B on the 10th. He's breached the contract before it was even due.
And this one is your classic, straightforward, actual breach. The due date, February 1st, rolls around, and no sugar. A simply fails to deliver. The failure to perform happens right on the day it was supposed to. It's a clear violation of the contract's terms, right on schedule.
All right, now for the really practical stuff. The part that really matters. The contract is broken, you're the one who's been let down. What can you actually do about it? Well, this is where we open up what I like to call the legal toolkit.
And this is everything. It's not just some abstract concept for your exams. Understanding the answer is fundamental to knowing how contracts actually work in the real world.
And here it is, your legal toolkit. The law gives you 5 main remedies to choose from, and each one is designed for a specific kind of situation. We're going to start with the most common one, a suit for damages, and then we'll get into how you can cancel the contract, get paid for work you've already done, and even get a court to force someone to do something or stop them from doing it.
Okay, let's kick things off with the most frequently used tool in that toolkit, suing for damages. At its heart, this is all about getting financial compensation for the loss you've suffered because of the breach.
The first category is what we call ordinary damages. Think of this as compensation for the direct, predictable, and totally natural results of the breach. If someone was supposed to deliver goods and didn't, and you had to buy them elsewhere for a higher price, that price difference is your ordinary damage. It's what anyone would expect to happen.
Now, this idea is based on a really famous old case, Hadley versus Baxendale. Long story short, a mill's main crankshaft broke. They gave it to a carrier to take for repairs, but the carrier was late bringing it back. Here's the kicker. The carrier had no idea that the entire mill was shut down just waiting for this one part. So the court said, look, you're liable for the delay, sure, but not for all the mill's lost profits, because that was a remote, indirect loss you couldn't have known about.
And that leads us perfectly into special damages. You can actually claim for those more unusual losses, like those lost profits, but there's a huge if. You can only get them if you specifically told the other party about your special circumstances when you were making the contract. They have to know what's really on the line.
And then there are a couple of other types. Vindictive damages, for instance, aren't really about money lost. They're more about punishing the wrongdoer for something like hurting your reputation. Then you have nominal damages, which are symbolic. A court might award you 1 rupee, just to make the legal point that, yes, a contract was breached, even if you didn't actually lose any money.
Okay, definitely pay attention to this slide, because this is a big one for your exams. Sometimes people write the damages right into the contract. Now, English law cares a lot about whether it's a genuine estimate, called liquidated damages, or just a huge number meant to scare someone, a penalty. But here's the key. Under Indian law, that distinction doesn't really matter. The court will ignore the label and just award reasonable compensation, up to the amount you stated. It's not going to enforce a penalty just for the sake of it.
So let's move on. Because, sometimes money just can't fix it. The loss might be something you can't put a price on, or maybe just need something else entirely. For those times, the law has some really powerful remedies that aren't about money at all.
First up is rescission. Just think of this as the legal cancel button. If the other person breaches the contract, you can just declare the whole thing over. And what's so powerful about that is it frees you from having to do your part of the deal. And you can still sue them for any damages you suffered up to that point.
Now this one is a serious heavy hitter. Specific performance is when a court literally orders the other person to do exactly what they promised to do. Courts don't do this lightly. They save it for when the thing in the contract is unique, like a one-of-a-kind painting, a rare car, or a very specific piece of land. In these cases, you don't want the money, you want the thing itself.
An injunction is basically the mirror image of specific performance. Instead of forcing someone to do something, it's a court order that stops them from doing something they promised they wouldn't do. The classic textbook example: a movie star signs an exclusive contract to work for one studio. An injunction can legally stop them from going and working for a rival studio.
Finally, we have quantum meruit. Now, don't let the Latin throw you off. It simply means as much as is earned. And it's all about fairness. Let's say you've done half the work you were contracted to do, and then the other party illegally ends the contract. Well, quantum meruit lets you claim a reasonable payment for the work you've already completed. It makes sure no one gets to benefit from your labor for free.
So to wrap it all up, the slide asks a fantastic question. Which tool is the most powerful? And while it's easy to think of something dramatic like a court ordering specific performance, the real takeaway here is that a breach of contract is never just an ending. It's actually the start of a legal remedy. The real power isn't in any single tool, but in knowing which one is the right one for the job. Thanks for joining me on This Explainer.